So now, it is my pleasure to welcome Leanne Monsma, LLP. Leanne is an Edmonton-based lawyer practicing in the area of professional regulation, labor, and privacy. She assists numerous professional regulatory organizations in Alberta and provides advice on issues such as governance, registration, professional conduct, unauthorized practice, and legislative compliance. Leanne routinely offers live presentations and webinars to her clients. Most recently, Leanne has offered presentations on Bill 21, similar to the ones that we're going to listen to today, and its impact on professional regulatory organizations and their members. In the past, she has also offered presentations or webinars on professional discipline investigations, cannabis in the workplace, and the impact of the Me Too movement in the workplace. So again, it is my pleasure to welcome Leanne, and now over to you, Leanne.
Hi, everyone. I'm Leanne, and I just want to thank you very much for joining me this morning. It's a pleasure for me to be able to present to you on this topic, Bill 21. We have 1 hour and a lot of material to cover, so let's go ahead and get started. So just to make sure that we're all on the same page here, Bill 21 is titled An Act to Protect Patients, and it was passed by the Alberta government towards the end of last year. Now, Bill 21 doesn't actually create a new piece of legislation. Instead, what it does is amend the Health Professions Act. The amendments took effect in 2 different waves. The first wave took effect in November, and then the second wave took effect in April. So I want to provide you with a quick overview of the topics we're going to address during the webinar today. I'm going to start by talking about Bill 21 a little bit more. Now, Bill 21 introduces 4 new phrases to the Health Professions Act, and I want to spend some time going over the definitions for those phrases. The phrases are sexual abuse, sexual misconduct, sexual nature, and patient. Now, if a regulated member is found to have committed sexual abuse or sexual misconduct against a patient, Bill 21 sets out what some of the consequences will be. I want to cover what those consequences are. Following that, we'll discuss Physiotherapy Alberta's new standard of practice and what it says about Bill 21. Bill 21 also introduced some mandatory reporting requirements for members, and so we'll discuss those as well. And then finally, turning to the practical side of things a bit more, we'll discuss some tips and traps for how to ensure compliance with Bill 21 and protect yourself against risk. And then we'll watch a little video together, and using everything that we've talked about today, we can analyze the video. So turning back to Bill 21 itself, the objective of the legislation was to create a comprehensive regime to protect patients by preventing and addressing sexual abuse and sexual misconduct by health professionals. Now, Bill 21 was first introduced to address a concern that in cases where regulated members under the Health Professions Act were found to have engaged in unprofessional conduct of a sexual nature with a patient, that the hearing tribunals were not imposing harsh enough penalties. So policymakers were concerned that patients weren't being well enough protected. So in an effort to better protect patients going forward, Bill 21 introduced 4 definitions into the Health Professions Act. Now, I haven't included the full definitions on the slides, but they're actually set out in the college's standard of practice on sexual abuse and sexual misconduct. I want to start by talking about the definition for sexual abuse. It has a rather long definition. It's the threatened, attempted, or actual conduct of a regulated member towards a patient that is of a sexual nature and includes sexual intercourse, genital to genital, genital to anal, oral to genital, or oral to anal contact. It also includes touching of a sexual nature of genitals, anus, breasts, or buttocks. Now, this is an oversimplification, but in short, sexual abuse is the really serious stuff, and what we might think of as giving rise to sexual assault. The next key definition is for sexual misconduct. It's defined as any incident of objectionable or unwelcome conduct, behavior, or remarks of a sexual nature that the member knows or ought reasonably to know will cause offense or humiliation or adversely affect the patient's health and well-being. So I mentioned that we could sort of think of sexual abuse as being like sexual assault. We can then sort of think of sexual misconduct as being like sexual harassment. So there's a really big range of conduct here. It could include texts, quote-unquote jokes, or actual physical conduct. It could be really serious, or it could also be much more minor. Now, in talking about the definitions for sexual abuse and sexual misconduct, I mentioned the phrase sexual nature, and that's another one of the key definitions. In order for sexual abuse or sexual misconduct to have occurred, whatever happened must have been of a sexual nature. The definition for sexual nature is simply does not include any conduct, behavior, or remarks that are appropriate to the service provided. So this sort of creates an exception. If you touch a patient's butt simply because you want to, that will constitute sexual abuse or sexual misconduct. However, if you touch a patient's butt because you're trying to assess whether they have increased tone in their glutes, then it won't. Finally, I want to talk about the definition of patient. Now, Bill 21 applies to patients. So the definition of who is a patient is obviously really important then. However, the definition for patient set out in Bill 21 actually just says that a patient means a patient as set out in the standards of practice. So in other words, and I think this was right, the government recognized that patient might mean different things for different health professions, and so each regulatory college was allowed to come up with its own definition for patient. We'll talk about how your college chose to define a patient a bit later on today when we go over your standard of practice. Now, I want to just highlight something really quickly here. When it comes to the definition of sexual abuse, it doesn't matter whether the patient consents to the sexual relationship. The reason for that, and this is something that Bill 21 is really built on, is that a patient isn't capable of providing valid consent in this situation because of the power imbalance between the patient and the physiotherapist. So if a member is found by a hearing tribunal to have committed sexual abuse, the member's practice permit and registration must be permanently canceled. There's also the potential for other sanctions. An example of such an other sanction is something like having to pay the costs of the investigation and the hearing. So the significance of this consequence is obviously huge. However, I want to be really clear about one thing. This isn't what happens if a member is accused of sexual abuse. No, this is only what happens if a hearing tribunal makes a finding that a member has committed sexual abuse. So what this basically means is that a complaint came in, the college decided to investigate it, a full investigation was done, and on the basis of that investigation, the college decided to send it for a hearing. And then after a full hearing, the hearing tribunal decided that sexual abuse actually occurred. The consequences of a finding of sexual misconduct are potentially less serious. So if a hearing tribunal finds that a member committed sexual misconduct, Bill 21 requires the hearing tribunal to at least suspend the member's practice permit for a period of time. However, Bill 21 doesn't set any limits for how long the suspension needs to be. So the suspension might be for 1 week or it might be for 2 years. This makes sense if we think back to the definition of sexual misconduct and the wide range of conduct that it can potentially cover. It might be something really serious, but it might also be something less serious, like an inappropriate joke. So let's talk now about Physiotherapy Alberta's standards of practice. There are actually 2 important ones to highlight here. There's the standard on sexual abuse and sexual misconduct, but there's also the standard on professional boundaries. The one on professional boundaries was in place even before Bill 21, but the one on sexual abuse and sexual misconduct is a direct result of Bill 21 and just came into force in April. I can't emphasize this enough. Read the standards of practice. Get familiar with them, understand them, think about them, and do all of this regularly. Have an annual read-through of the standards of practice. It's so important that you know what they say. So we're going to focus now on the standard on sexual abuse and sexual misconduct. Now, what this standard really does is incorporate Bill 21 into the college's standards. So it prohibits a physiotherapist from engaging in sexual abuse or sexual misconduct with a patient. And it also clarifies who a patient is. So a patient is an individual who is the recipient of physiotherapy services where a therapeutic relationship is formed. So when is a therapeutic relationship formed? A therapeutic relationship is formed when a physiotherapist has engaged in one or more of gathering clinical information to assess the individual, provided a diagnosis, provided physiotherapy advice or treatment, charged or received payment from the individual or a third party on behalf of the individual, or received consent from an individual for physiotherapy services. And then the definition also explains that a patient is deemed discharged and no longer a patient if there have been no physiotherapy services provided for 1 year. So Bill 21 and the restriction on sexual relationships applies during this year. If a physiotherapist engages in a sexual relationship with a patient, that will constitute sexual abuse even if the patient consents. Having said this, though, there are some exceptions for the definition of who is a patient. A person is not considered to be a patient if a current sexual, spousal, or adult interdependent relationship exists at the time the physiotherapist provides physiotherapy services. So that underlined bit is important. It doesn't matter if a spousal relationship forms afterwards. It has to be current. This exception means that a physiotherapist may still treat their spouse, and that will not constitute sexual abuse as long as the sexual relationship already exists at the time physiotherapy services are provided. There's also an exception in the standard for where the physiotherapist has only provided episodic care to the patient. A person is not considered to be a patient if the physiotherapist provides episodic care to them and 48 hours have passed before the sexual relationship or communications occur. Episodic care is defined in the standard as a single encounter with a patient focused on a presenting concern where neither the physiotherapist nor patient have the expectation of an ongoing care relationship. Now, it's not enough for the physiotherapist to have no expectation of an ongoing care relationship. The patient needs to be on the same page as well. So as I said at the outset, Bill 21 also introduced some mandatory reporting requirements for members. There are 3 types: employer reporting, self-reporting, and reporting others. So the Health Professions Act has always required employers to report certain things to Physiotherapy Alberta. For example, if the employer suspends or terminates a physiotherapist because of conduct that is, in their opinion, unprofessional conduct, they've always had to notify the college of that. Now they must do so as soon as reasonably possible under Bill 21. And then also, if an employer has reasonable grounds to believe that the conduct of a member might constitute sexual abuse or sexual misconduct, they must give notice of that to the college as soon as possible. There are also some new self-reporting requirements for members. So a member must self-report to Physiotherapy Alberta in a few different circumstances. If the member is also a member of another college, so let's say the member is also a registered nurse and a member of CARNA, and CARNA makes a finding of unprofessional conduct against the member must report that to Physiotherapy Alberta. Then there's also if the member is also registered in another jurisdiction. So if you're registered in Alberta and BC, and the BC college makes a finding against you, you must report that to Physiotherapy Alberta. And then if there's a finding of professional negligence against you, so if you're sued personally and the lawsuit against you is successful, that needs to be reported. And sorry, we're not done yet. The first bullet point here should have been on the previous slide. A member also needs to self-report if they are charged or convicted with a criminal code offense. Turning to reporting of other regulated members. The first thing that you need to understand is that this doesn't just require you to report other physiotherapists. It applies to other professions under the Health Professions Act. So that includes physicians, all types of nurses, chiropractors, occupational therapists, etc. And what do you need to report? So, if in the course of acting in your professional capacity, not your personal capacity, you have reasonable grounds to believe that another regulated member may have engaged in sexual abuse or sexual misconduct, you must report that to the complaints director of the regulated members college. There is, however, an exception if you obtained the information in the course of providing professional services to the other regulated member. So, for example, if a physiotherapist was concerned that they might have violated a boundary, they could go speak to a psychologist about the incident, and the psychologist wouldn't be required to disclose that information to Physiotherapy Alberta. Okay, I know that's a lot of information to take in. As I said at the outset, I want to quickly go over some practical tips for avoiding boundary violations or issues. Now, I want to be clear about something right away. Some of these tips are aimed at making sure that you don't engage in sexual abuse or sexual misconduct. However, a lot of the tips are aimed at being preventative or proactive and making sure that you don't even face these types of complaints or allegations in the first place. So what can you do to make sure that a patient doesn't even accuse you of sexual abuse or sexual misconduct? In mentioning a bunch of these, I'm not saying that you need to practice strict adherence to the tip. I just want you to understand some of the things that could potentially increase your risk. Okay, I can't emphasize this enough. Go read the Standard of Practice. It's on the college's website. This is something that absolutely every single physiotherapist has to know and understand. And this is a pretty nerdy thing for me to admit, but on the anniversary date of when I become a lawyer, I try to review the Law Society's codes of conduct and rules. Professionals get into so much trouble because they forget the rules and standards that apply to them. Read this Standard of Practice and then probably read the rest of them too. Understand these definitions. As I said before, they're set out in the standard. I particularly want to encourage you to think about what might constitute sexual misconduct, because it can be a little gray. It's unlikely that a physiotherapist will accidentally engage in behavior that constitutes sexual abuse. But a physiotherapist could absolutely engage in conduct that constitutes sexual misconduct without even realizing it. Recognize the risk factors. So risk factors for boundary violations are things like lack of knowledge of the standard or other professional obligations, physical and mental health issues, including stress and burnout, working in isolation, workload, and one other thing that comes up a lot in these types of cases is this belief that the rules don't apply to me or this specific situation. Then it's also important to identify high-risk situations and implement preventative measures. So a lot of these tips relate to preventative measures, but two important strategies here are going to be, one, request a coworker to be present. So maybe this is an aide or some other person in the clinic. Or two, and it's related, invite the patient to have someone accompany them. You're better protected when there's another person around. So by introducing yourself by name and communicating that you're a physiotherapist, you establish that this is a professional relationship. This can set the tone for your entire relationship with this patient going forward. Likewise, use the patient's preferred name or title in all communications with them. This again helps both parties to maintain professionalism in the relationship. Most patients will probably ask you to call them by their first name, and that's fine. Just understand that it's a lot easier to have the boundaries start to erode with someone you're calling by their first name as opposed to someone you're calling Mr. or Mrs. So-and-so. So informed consent isn't a new concept for any of you, I hope, but it's also really important from a Bill 21 perspective. Informed consent is particularly important when it comes to procedures that could be misinterpreted. So again, before checking a patient's glute for tone, explain to them what you want to do and why you want to do it, and then write down that you obtained this informed consent. This is another important piece. Make sure that you're communicating in a way that facilitates the patient's understanding. So as a really easy example, you might ask a patient if it's okay for you to touch their glute, and the patient might be sitting there thinking, what the heck is a glute? Be mindful of who you are talking to and use language that they'll be able to understand. So as a general rule, try not to be too touchy-feely with a patient. So for example, don't absent-mindedly rest your hand on their leg while you're talking to them. And like I said at the outset, this doesn't necessarily mean that you can never touch a patient unless it's part of treatment. You might decide to give them a hug or pat them on the back for some reason. I just want you to be intentional about how you use touch with patients and to really think about it beforehand. Again, this tip won't be a new concept. Good charting is so important. If a complaint is ever made about you, the chart is going to be a key piece of evidence in the investigation and if there's ever a hearing. I would especially encourage you to chart when things sort of go sideways. So if a patient responds really oddly to something you do or say, write that down too. So if you disclose personal information about yourself, a patient may perceive that to be crossing a line. It may also lead to more personal and less professional relationships, and that obviously increases the risk that some sort of boundary violation will occur. This is again an example of a tip that you might not want to strictly adhere to 100% of the time. However, if you are sharing personal information with a patient, you should think about it and be intentional about it. Also avoid practicing outside of normal professional customs. So ours is a good one to think about here. I know that physiotherapists, particularly in private practice, might work somewhat unusual hours to accommodate their patients' schedules. So maybe you're treating patients at 6:30 in the morning and 8 o'clock at night. Still though, as a general rule, 10:30 p.m. when no one else is left at the clinic, that's probably not a good time to treat someone. So the entire flavor of the workplace is going to affect things here. If a patient is overhearing the physiotherapist, the aide, and the front desk person make dirty jokes, then even if no one says anything offside to the patient directly, that's going to influence what the patient perceives. And remember, what you think is an innocent joke might not be seen the same way by some patients. So I want to spend some time talking about online communications. The way I see it, you might come into contact with online communications in two main ways. First, you might use email or text to set up appointments and things like that. And then second, you might use social media for marketing purposes. So things like Instagram, Facebook, and Twitter. The first tip is to think already now about how you're using these things and make a bit of a plan or strategy. Establish some ground rules for yourself up front. Second, whenever you're communicating with patients online, maintain a professional communication style. It's really easy to get informal over text, and the more informal the communication, the more risk there is. risk that you'll see the patient as a friend or possibly someone to date, or risk that the patient will misinterpret things and get ideas in their head. Finally, I encourage you to have separate personal and professional accounts. Again, just maintain those boundaries. And if you have a personal account, be careful about identifying yourself as a physiotherapist on that account, because then everything on that account will be perceived in that light. And if you do end up in a situation where a patient is making a move, address it head on. Explain your obligations and your responsibilities, and then make absolutely certain to document exactly what happened. So also know what sorts of things to be on the lookout for. Do you dress differently when a certain patient is booked to come in? Do you act defensive when your relationship with the patient is questioned? Do you provide better or longer treatment to a certain patient? Do you exchange gifts with them? Do you tell them a lot about your personal life? If you start noticing these things, then you may need to terminate the therapeutic relationship and transfer care of the patient to another physiotherapist. Don't be too reluctant to take these steps. If you think back to what the consequences of sexual abuse and sexual misconduct are, the consequences are really just too severe to take the risk here. And if you do end up in a situation where you want to start having a romantic relationship with someone that you previously treated, make absolutely certain that the person is no longer a patient under the standard of practice. Did you only provide them with episodic care, or has a full year passed since you treated them? And if you're unsure, contact the college and check. Okay, so I'm going to stop talking now for a bit, and we're going to watch a short video. The video portrays a doctor and is actually one in a series of videos intended to capture what sexual harassment can look like in real life. As we watch the video, think about the 20 tips and traps we just went over and see how many boundary issues or risks you can identify. Also pay attention to the patient's reaction and expression as things unfold.
Hello, I'm Dr. Savik. How can I help you?
Oh, hi. Where's Dr. Patel?
He's on vacation. So what seems to be the problem?
I have this terrible pressure under my eyes and my head feels like it's going to explode. I'm incredibly weak. I could almost not get out of bed this morning.
Okay. How long has this been going on for?
Like 2 days.
Okay, let's take a look. Can you,
Yeah.
turn this way and just bend over for me?
Bend over?
Yes. Bend over, please. That's how we check for sinusitis. It sounds like you have sinusitis.
Oh, okay.
Come on, all the way down.
Okay.
There you go. A little more. Good. Okay. Does that hurt?
Yeah, that's very painful.
Okay, sit up. There you go. Let's take a look. Open your mouth. Stick out your tongue. Wide. Okay. Let's see.
Sinusitis?
Patience. You need patience.
I have patience.
Okay. Does that hurt?
Sort of.
Here?
Yeah, it does.
There?
Yeah, a bit.
Right there. All right. Okay. Let's see. There we go. Take a deep breath for me. Good. Okay. Lie down. Can you just undo a button for me? Maybe one more.
Okay.
There you go. Great. Okay. Okay. Take a deep breath. Yeah. Another one. One more. Great. How old are you?
I'm 50. Why do you ask?
Have you had a mammogram lately?
Not in a while.
You should. You have a lovely chest. It'd be a shame not to have it checked. I just mean that there's a small indentation there, and it
An
could
indentation?
Just could be indicative of a lot of things.
Oh my God, where?
It's
Jesus.
tiny. No, it's not a problem. But you should have it checked. Do you ever check yourself?
No, I
You
don't
should.
really.
Here, I can show you. Put this. It's easy. Put your head behind your head. There you go. Turn your head this way. There you go. And you just feel around. You circle there. There you go. See if you can feel anything. Nope. I don't think there's any problem at all. I think you're fine. I wouldn't worry about it. You have any allergies to medications?
Not that I know of. So, what do I have? Sinusitis?
Classic case of sinusitis.
Okay, so I understand that the volume might not have come through on that video for some of you. Sorry about that. As we go through some of these, I'll try to provide just a little more detail about what was said. Fortunately, a lot of the issues that you should have picked up were physical ones as well. I would recommend, though, if the sound didn't come through, that perhaps after the webinar is done, you just pop onto YouTube and you can look up this video and watch it to have the sound that way. So I won't go over every single one of the 20 problematic behaviors, but perhaps that's something that you can do if you watch it afterwards. So the few that I want to highlight. At the start of the video, he told her to bend over without initially telling her why, which was that he was checking to see if she had sinusitis. He then proceeded to touch her very frequently without asking for consent to do so or even explaining why he needed her to do so. He also very absent-mindedly, it appears, touches various parts of her body, sometimes to get her to move in a certain way. For example, near the start of the video, he put his hands on her shoulders to push her head down. But then he also just frequently rests his hands on her while he's talking to her. He also touches her in order to provide treatment or examine her, but he very rarely explains why. So he doesn't explain why he's going to tap her forehead area, and he keeps his hand on her thigh. He also spoke to her in a little bit of a rude way. When she asked if it was sinusitis, he responds, "Patience. You need patience." So things get especially problematic when he turns to more sensitive parts of the body. He starts talking about whether she's had a mammogram and how old she is. And then he tells her to undo the buttons on her blouse, but he doesn't explain why. He also doesn't explain why it's not enough when she initially only undoes one button, we would have expected him to say something there like, "Oh, sorry, I actually need more access. Would you mind undoing one more button?" He also is fairly rough when he opens up her blouse, and then he rests his other hand on her stomach. He asks her age, and perhaps that's medically relevant to the issue of getting a mammogram, but the patient doesn't know that. He also, towards the end, commented to her, "You have a lovely chest. It would be a shame not to have it checked." So he comments on her physical experience with a sexual undertone. You saw towards the end of the video that he conducted a breast examination on her. Well, you wouldn't have heard this, but there was actually nothing to hear because he didn't ask for explicit consent before touching that extremely sensitive part of her body. He also squeezes her breast at the end of the examination and gropes the patient, and then he pats her on the breast area. So a few things to think about. Is this sexual misconduct or sexual abuse? The comment about her having a lovely chest could constitute sexual misconduct, and the groping for no medical reason would be sexual abuse. Does the patient know that she's just been assaulted? And what do you think she will do? Do you think she might sue him, complain to the hospital or clinic where he's working, complain to the college? Maybe she'll do nothing. And this last question is an interesting one to think about. Do you think that it was wrong for her not to call the doctor out on his actions? The research in this area suggests that we expect people to act in a certain way in these types of situations, but that's not actually how people typically act. Apply this to your interactions too. You might tell an inappropriate joke and think that since your patient laughed, the joke is okay, and you can tell more jokes like that in the future. However, your patient may actually have felt really uncomfortable and not have known how to react. So again, starting to be a broken record, I just want to highlight the standards. They're available on the college's website. Please review them. And now I think we have some time for questions.
Okay, thank you very much, Leanne. That was excellent. And we do have a few questions, so I will start by reading the question and then let you go ahead and answer it. So the first question is from Karen, and Karen wants to know if the suspension is up to 5 years, that in essence would be cancellation of a permit as the requirements for work hours set by the college would not be met. Is this correct?
Yes, that's correct. So up to 5 years, you would then after that suspension have to apply likely for reinstatement. But that's a key difference between the punishment for sexual abuse and sexual misconduct. So sexual abuse, you can never apply for reinstatement, and sexual misconduct, you still could.
Okay. I have a couple of people who are wondering why is there a distinction on reporting a member of another college between the PT finding out about the other professional's behavior in their professional context versus their personal context? Example, why does it matter if the PT learns an MD is having sex with a patient in their work role versus their personal life?
So I I'm not sure what the government's rationale for that was. I'm thinking, I'm guessing that it might have something to do with just trying not to interfere too significantly with professionals' personal lives. And it is going to be a little bit of a gray area because I think it's hard to say when you're acting in your professional capacity as a physiotherapist and when you're in your personal capacity. Perhaps you're friends with other medical professionals that you work with. So the lines there could definitely be blurred. But I suspect that the distinction is there for a situation where perhaps you're having a beer with someone you went to high school with and they've gone on to become a doctor and they start telling you, look, I've started to develop feelings for someone who might have been my patient and I'm not really sure if I might be violating a boundary here. I don't know what to do. And I think that we didn't necessarily in this legislation want to interfere with those types of conversations. That's what I would suspect.
So there's no mandated requirement to report, but if it's something different than that kind of conversation, could you report?
Right, that's a good point, Nancy. Yeah, it's not mandatory to report in that situation, but you still always have that choice. If you think, you know what, I think this really needs to be reported to the college. I tried to talk to my buddy about this and how this wasn't a good idea. He's not listening to me. I've got to do something. I'm going to the college. That is absolutely an option that's available to you.
Okay, thanks. So Jason asks, from a legal standpoint, is it most appropriate for the provider to document the client's provision of informed consent or for the client to sign a standardized form as an expression of their consent?
I would say best case scenario is to have both. I think that forms are useful and they're good to have on file, but they're not going to be practical, most likely, or enough. I think that it's important that anytime you're touching a patient, you get their consent to do that. And I don't think that you're going to have 10 different consent forms to be filled out during the course of a treatment. So I think it's important to get that consent form out front for services generally, but then as you're going along and you need to touch the patient here or there for this purpose or that purpose, that you also get consent in those instances. And then that's where it would be really important to include that you got that consent in the chart.
I think also from a Physiotherapy Alberta standpoint, we also like to strongly remind members that the signature in and of itself is not good enough. The individual has to understand, it has to be informed. So the discussion is as important as just a signature on a form may be, which is where the intake forms, signing consent in an intake form doesn't cover the informed part of consent. Yeah,
and I can tell you, if I was looking at a case where a member had been accused of sexual misconduct because they touched a patient and the member attempted to defend against that complaint by simply pointing to a general consent form that was signed at the outset of treatment, that wouldn't be great solid evidence for the member.
Okay. Shauna wants to know, does patient include the family that are with the patient?
So that's not something that the standard of practice specifically addresses. I would say that one useful place to look there is the other standard of practice on professional boundaries. And that one talks about substitute decision makers. Nancy can weigh in on this as well, but I would say that I would have some significant reservations about proceeding into a relationship with a substitute decision maker of a patient, but potentially less concern if it was some other family member. So, for example, if a parent, an adult parent, brought their adult child along with them, and the adult child wasn't there to help make decisions about the parent's treatment, but was there instead as a support person.
Yeah, I would have to agree. Certainly, with a decision maker or an agent, I would be extremely cautious, although it's not actually in the definition. And going back to the therapeutic relationships, the understanding of everybody needs to understand the roles and what the position.
I would really recommend. Sorry, just to follow up with that. That question's a good example of why it's so important to go to the standard of practice and to look at all of the definitions and to really think about them and how they might apply to those types of situations.
No, exactly. If there's a little red bell or red flag or a little bell ringing in the back of your head and you're wondering, is this appropriate? Probably you should err on the side of caution. I think that's what I would suggest.
Yeah, absolutely.
So Carson asks, as a consultant, when patients report their concerns, should we direct them to the college first or to contact the clinic or manager?
I would say both.
Mm-hmm.
Or it might depend on the circumstances, whether one's a little more appropriate than the other. But ultimately, I think the complaint is going to make its way to both locations eventually. But you never even know who the patient is going to feel more comfortable talking with those concerns about. Some clinics might be really well set up to receive those types of complaints and handle them. Other clinics might not be. And so I think just to cover your bases and make sure that the patient is going to have a venue where they can raise those types of concerns, it's a good idea to mention both the college and the employer as options.
Okay, we have one comment from, this was a fantastic presentation, very air-clearing about Bill 21 that has raised so much unease with PTs, especially males practicing in private practice. Thank you. So, excellent. William wants to know if you could give an example of an episodic encounter.
Well, I think one big and easy one would be the situation where you have a PT working in a hospital, potentially in a rural town where perhaps it's pretty frequent or easy to run into someone socially that you've seen in the hospital, maybe for treatment. So perhaps a physiotherapist just swung by the person's room to do a quick consult before they were being discharged. There's no suggestion that they would ever be seen on an outpatient basis, and it really was just a one-time treatment or assessment of the person before they left the hospital. And then 48 hours later, these two individuals run into one another at the movie theater or something like that, and a relationship starts to develop.
Okay. Another example would be Lots of members are involved with sporting events and that kind of thing, and they would see someone on a football field to tape an ankle or do something like that. That would also be, I believe, considered an episodic care, in that it's a one-time on the thing, and there's no expectation that there will be any other ongoing therapeutic relationship.
Yeah, I would agree with that one too. The interesting thing would be if there is discussion in that situation, in that example, if the person who is having their ankle taped started saying things like, oh, I've been having issues with my ankle, maybe I'll come in to see you next week as well. I think I need to get some exercises and do some strengthening, stuff like that. That might change things.
Yeah, for sure, because then there's the expectation of an ongoing therapeutic relationship.
Yeah.
So we have several more questions. So if people have to leave before the questions are done, we're going to continue and answer all the questions that come up. We can stay past 9, but please remember that the webinar is recorded. All the questions and answers will be recorded, and you will be able to find them on the website under the Exchange tab within a day or two. Okay? So we're just going to plow on through and keep answering all these questions, because there's lots of really good ones. For manual muscle testing, we need to touch to provide counter support and to provide resistance. Sometimes we do this from head to toe in one assessment. How would you recommend we explain this? Is once at the beginning sufficient?
So from my perspective, what I would like to see legally would be for the physiotherapist to explain that at the outset, and to also highlight what sensitive parts of the body they might have to touch as they go through and do this, and to obtain consent at that time. And then I think also, as you go through it, I would also explain it and reconfirm consent, particularly when you start to get around sensitive parts of the body. So say, is everything going okay so far? Now I need to put my hands here. I need to do this. Is that okay? And that's a good reminder, too, that informed consent really does need to be ongoing. Just because you obtain it at the very beginning, well, the patient might change their mind partway through. And so that's something that we kind of need to keep assessing and checking. Is this still okay? I'm going to do this now. Be prepared for this. And is this still okay? Was that okay?
Mm-hmm. Perfect.
But yeah, I think particularly any time before you touch a sensitive part of the body, it's important to just double check or triple check that touch is going to be okay.
Okay. In the video, did the doctor document informed consent without actually having obtained it? I don't know if we know if he documented anything, but...
Yeah, I seem to recall that he was perhaps writing some stuff down at the very beginning of the video. So if he did document it, he definitely didn't obtain it, but I'm not totally certain that he did document it.
Okay. Can you please give us more clearer examples related to tips and traps on avoiding informal communication?
Is that online communication, do we know, or? I guess, I think that,
I'm not sure.
I guess I talk about it in both ways. When we're talking about online communications, I think one way to keep things more formal, for example, is to always include some sort of signature that refers to your full name and the fact that you're a physiotherapist. So even if you had a general practice of signing off on all your emails and texts about appointments and appointment reminders, to include that little signature line or some other statement about your clinic, just to bring it back to this professional relationship. And then I think it's other things like just being mindful of how formal your language is. Like, are you saying, hey, or are you saying, dear so-and-so? One good way to make sure that you're maintaining some formality and professionalism in your online communications is to rely heavily on the use of templates. So create a little template for appointment reminders or confirmations, or even for setting up appointments, that always include this specific information in this order, and that can help to maintain the professionalism.
Okay. If a patient wishes to report to the clinic management about abuse, is there a format to do the incident report? Physiotherapy Alberta certainly doesn't have any templates that would be used within the clinic. This member also then goes on to ask, does the clinic manager need to report to the college before there's been some proof of guilt?
Yes, absolutely. So anytime, the way that the Health Professions Act has structured these reporting obligations is basically just to say that if the clinic manager suspects that it might be sexual abuse or sexual misconduct, then they need to report. So a question there that you're essentially asking yourself is, okay, if I believe that what this person has said is true, would that meet the definition, or could that meet the definition of sexual abuse or sexual misconduct? And if the answer to that is yes, then that report should be made to the college.
Okay.
And so all of that would occur even before an investigation has occurred.
Okay. How did the college decide on the cool-down periods of 365 days?
Nancy, I think that's a question for you.
I know there was lots of discussion, and there's different colleges that have different timelines. Some are very rigid, and I believe it's never. And then some are shorter time frames. 365 days or 1 year was what council decided was an appropriate cool-down period for our members. I wasn't in on the discussion, so I can't give you any more background than that. But it was a decision that each college had to make.
Yeah, I think just more generally that was, something that each college had to decide what made sense. As Nancy said, some colleges in some instances have it where relationships can never occur. That tends to be where the treatment involves some sort of psychosocial interventions. And then there are all different approaches that were taken. I know one other college said that it didn't necessarily have to be a specific amount of time that had passed, but it would depend on a number of factors, like how long treatment had occurred over and what exactly the treatment entailed. But one of the things that they did was then had the member write to the college for approval if they were going to start a relationship within a certain window of time. So there were and there are a lot of different ways with dealing with this, and it was sort of left to each college and their council to figure out what would work best for that profession in most situations and then apply that rule.
Okay, thank you. In the case of a complaint, what is the best source for physiotherapists to gain legal support from?
Nancy, I'm not. Yeah, so the college.
They'd have to get their own lawyer, I would guess.
Yeah, I'm not sure what the association all provides and what access to resources they might have. If you do need a referral for your own lawyer, then the college can sometimes be a good person to ask. I know I've had that with other colleges that I work with where the member is looking for legal counsel, and just by virtue of my experience with working these types of cases, I'm able to recommend a good lawyer to them, completely separate from the college. Some other physiotherapists who are in public practice might have access to union reps if they're members of AUPE or something like that.
Yeah, Physiotherapy Alberta, we generally do not make any recommendations for personal legal counsel. We wouldn't be able to direct an individual to a specific lawyer. That's beyond our jurisdiction to do that. So those other options, would be appropriate. Talk about ongoing consent. I think we've talked about ongoing consent and that it's absolutely necessary. It's never a one and done type of scenario. Remind the title of the video to look up on YouTube.
Yeah, so the title of the video is #That'sHarassment and then the doctor.
Okay.
So even if you just typed those two phrases, #That'sHarassment and the doctor, into Google, the link for the YouTube video should come up.
Okay, perfect. I'm just reading. It was suggested to document if sexual misconduct occurred in the direction of the patient towards the therapist. Does the college want to be informed of this as well? What protects the therapists? Ooh, good question.
So I think, again, if we think back to the definition of sexual misconduct, it could cover a wide range of behaviors, and some of them might not be problematic for one patient, but they might be problematic for another patient. So, for example, I talk about jokes often because they're such an easy one for people to have different preferences. You might be able to make one joke to one patient and not have that be an issue, but then make the same joke to another patient and have it really offend them or cause them or upset them. And so it's hard to say that sexual misconduct is black and white and is always going to occur when you do X or Y. And so I think that in those situations, it is important for a member to document, hey, I made this joke and I didn't think that it was inappropriate based on X, Y, and Z. And I think that even that helps to protect the member because it shows kind of what was going through their head and why they thought that it was okay to make that joke. And then if it does come to a finding of unprofessional conduct in that respect, remember that there is this huge range of sanctions. So if you have that type of information in your chart, like we had this previous relationship, she had made this joke to me before, she had said this to me before, and then I said this, well, that could be really important when it comes to determining how long the suspension is going to be for. Is it a one-day suspension because of all those other factors and all of that other information you included, or is it a 3-month suspension?
Okay. So, Leanne, I think, and there's a few questions coming up. If this question was directed, more from when the patient is harassing or making inappropriate sexual misconduct towards the therapist. So not the therapist towards the patient. There's several questions. Is there any document or any bills or legislation that protects the members in that way, the way that Bill 21 protects the patient?
Oh, okay. Not as specifically. I think that the best options then for a physiotherapist in those circumstances would be to, of course, document and then to document all of that as it's occurring, and then transfer care to someone else. Stop seeing that patient if that type of conduct is occurring and making you feel uncomfortable. Then the therapeutic relationship should end. And then from there, you can look to other sorts of possible ways to protect yourself. And I mean, that's going to depend a lot on the circumstances. Employers do have obligations to provide safe workplaces free from harassment. That usually means that your supervisors and your colleagues shouldn't be harassing you in that type of way. If there is a regular patient who's engaging in that type of behavior, well, then your employer might have an obligation to protect you from that type of patient in the workplace. And so maybe transferring care to another physiotherapist in the same workplace isn't going to be enough, and the clinic itself is going to have to stop seeing that person. But there are really any number of options there, but I would say that there isn't the same specific piece of legislation to really protect physiotherapists or other healthcare providers. We're looking more at other more general principles in the law.
Okay, so we're going to wrap this up here really soon. Just a couple of comments. Moira reminded me that in your malpractice insurance, members generally have coverage for professional issues, so you can look to that to assist you if you are being faced with some kind of a complaint. The responsibilities of PTs to inform their TAs and to consider potential risks when assigning interventions. Absolutely. If you're concerned and if there is a risk that you would be concerned about, you absolutely have the responsibility to ensure that you're only assigning interventions to TAs when it's appropriate to do so. So be very aware of that. The best way to word informed consent as being received during charting of a regular ongoing treatment. An example, verbal consent for treatment received after discussing the intervention or something like that, just to word it so that it's clear that you had a discussion and that consent was received. Is there a statute of limitations on when a patient can make a complaint? Do you know the answer to that?
Yeah,
no,
so a patient can make a complaint at any time, but the college only has jurisdiction under the Health Professions Act over a member for 2 years after the member stopped being a member. So I don't know if that makes sense. So if you're still a member of the college today and a complaint came in about you 10 years ago, there's no statute of limitations that applies there. But if you haven't been a member of the college for 2 years and then a complaint comes in, well then the college no longer has jurisdiction over that.
Okay, well, thank you, everyone. I'm not sure how many are still able to be on, but obviously there's still quite a few. So I really appreciate everybody's attendance and interest in this, and make sure that any of your colleagues who wanted to attend but couldn't review the webinar when it's posted, the recording. Thank you, everybody. And this is the last webinar before the summer break. So look for more information in the summer newsletters about the next season's webinars, which will start up in September. Again, thank you and have a great summer, everyone.
Thanks, everyone.